Okay, guys, we are on trademark law, still in the purple packet on page 134 of your study guide, this purple packet. We were talking about trademark law. Now, I've talked a little bit about intellectual property in the previous video, and we're going to go ahead and do some more stuff on intellectual property. The main things I'm talking about are things on the exam. There's a 2-page synopsis along with the 30 questions in the packet that has a lot of that stuff. That's what we're going over. We're going to hit about 15 pages worth of study guide material, and I'm only going to go over the things I've heard about being on the exam. I'm not saying don't look over it. Please look over it, but also understand that I'm going over the basic information that has been on previous exams. That said, we are on the middle of page 134, trademark and service mark. What is the difference between trademark law and service mark law? A trademark is basically dealing with a product or a good. A service mark is a mark associated to a service-based business. Now, does this fall under federal law? Absolutely, but it is not exclusively federal. The Lanham Act, also known as the Trademark Act of 1946, is what is in charge if it is done federally. If you get an R with a circle around it, that usually means Lanham has trademarked it. If it cannot be trademarked under Lanham for whatever reason, we'll go over a couple reasons a little bit later on, then trademark law can fall under state law as well. If it falls under state law, then it has jurisdiction not only at the federal level, but also at the state level, or one or the other, maybe not both at the exact same time. This is different than patent law or copyright law in that those are exclusively federal and have no state ties associated to it. So that said, what is a trademark? A trademark is any word, name, device, slogan, design, anything that's going to identify a product from its competitors within a given industry and commerce. So in business, if we're distinguishing one good from another, we're going to use a slogan, a short phrase, a name, a symbol, a slogan, a word, a design that's going to differentiate our product from other products. If it's a good product-based thing, it's going to be a trademark. If it's a service-based industry that say a slogan is or something like that, that's going to fall under service mark. Federal law, Lanham Act would apply if it applies. If not, you have state protection at various state levels. Why do we have trademark law? The primary reason we have trademark law is to avoid consumer confusion among similar or like-looking products. So there's two products that are fairly similar. We want you to be able to distinguish between our product and, say, our competitors. And we're going to do that obviously through quality, obviously through price, but more importantly, we're also going to be able to see it through advertising. And if we're going to be able to use words or slogans or phrases or designs or pictures or whatever symbols, then those things can distinguish our product from another product, and then you'll buy ours versus the other person's product. Okay? All right. For a trademark to be done, it must be arbitrary, fanciful, it must be suggestive, it must be descriptive. If it's too descriptive, it cannot be trademarked, and it can't be generic. If it's too common, that cannot be trademarked as well. And this is on the bottom page 134, the top of 135 in your study guide. Okay? I would note those four things. It must be arbitrary and fanciful, suggestive, descriptive, although not too descriptive, but descriptive enough, and it cannot be generic. If it's generic, then it very rarely can be trademarked. Okay? The registration process. You're going to establish a nationwide system for trademark law to be done under Lanham. And here's the thing. There are two types of systems. There's a test system and the TEAS system. There's a little thing that you might want to know. It's on the bottom page 135. One is TESS and one is TEAS. So the only difference between those is that third letter in the acronym. Well, that third letter gives us an idea of what it does. TESS, T-E-S-S, searches out across nation to see if that trademark is being used or conflicts with other people using that same basic trademark, whether it be a color scheme, whether it be a slogan, a phrase, a jingle, a design, symbol, whatever it is, okay? So the search engine is TESS for search. TEAS, A is for application. If you're applying for it under the Lanham Act, if you want to apply for a registered trademark, you're going to do it online with a TEAS. So I would note the difference between those two and what those two things mean, and that TESS or TEAS You think about it, it begins with a T, so it falls under trademark law, a little mnemonic device for y'all to remember that as well. Okay? When you file, you're going to file with the U.S. Patent and Trademark Office and use a test and T system and stuff like that. And you're going to use a current use filing. The registered must prove that they have the mark and they'll prove that they're the first one to use it. And you have an intent to use. You're going to use it maybe in the future. Now, we're going to talk about in the future a little bit later on in regards to the process and certain acts that apply. Because there's about 3 acts that also under trademark law in addition to Lanham that you might need to know about as well. We'll go over those in a little while. Okay, on the bottom of page 136, it says the competition can object to a proposed trademark information because public or filing. They can argue it, say the representation is not there and stuff like that, or they have some kind of a claim to it. However, on page 137, and I'm just going to let you look it over, number 8 at the very top, it has like 5 things, A, B, C, D, and E. All those things are generally not registrable under Lanham Act. And I would know all 5 of those, especially B and C. B and C have had their own basic questions. They may have been together, combined, but understand that A, B, C, D, and E are things that cannot be registered under Lanham. And if it cannot be registered under Lanham, what is your option? If it can't be done federally, you may have some protection at the state level, but you don't know that until you go to state. But those things cannot be registered at Lanham. Some of those are going to be descriptive names such as like Twin Cities or Tri-County or Tri-State. That doesn't tell you what states, it doesn't tell you what counties, it doesn't tell you what Twin Cities. Is that Minneapolis and St. Paul in Minnesota? Or is that what we call Bryan College Station, the Twin Cities sometimes as well? So you can't use those and trademark them. You can use them, but you can't trademark those things, okay? So understand that. And then also the things on number 8 on page 137 at the very top of the study guide. Now, we've been talking about durations earlier with copyright 70 years for the author, 95 years and all that stuff. Now we need to talk about trademark law. How long does a trademark last? Typically, once you get a trademark, whether it be at the federal level or the state level, but let's talk more the federal level, you're going to have it for 10 years. And this 10-year period can be renewed constantly over time. So that every 9th or 10th year, you're going to go and renew it. As long as you're using it, you should be able to get the renewal, no problem. If you haven't used it for 2-3 years, then you may lose it, okay? So think about it this way. If you don't use it for a certain time period, it can be taken away from you, but it typically lasts 10 years. And is it renewable? Absolutely, it's renewable. Thus, we need to think about it this way. If I gave you a question on the exam, say I was swimming, I gave you a question on the exam, and I said, what has the longest potential lifespan of all intellectual property? And if we're talking about just the big 3, copyrights, patents, and trademark law, if you think about it, well, it sounds like, 120 years possibly for copyrights, depending on if it was created a certain time period and stuff like that. Patents are only 20 years, non-renewable. If you think about it, potentially, trademarks can go 10 years and then can be renewed indefinitely, so it could go to infinite time period. And even if we're talking about lifespan of an author of 70 years plus their life, it's going to eventually, all people are going to eventually die. So trademark law has the longest potential lifespan. Well, what if the same question was given to you, like 2 questions later on the exam, which one has the shortest potential lifespan? Well, that would also be trademark law if you think about it, because if you do it for 10 years, but you don't renew it, that's 10 years. Patent is at least 20, and the copyright is going to be 95 years, 120 years per publisher, and author's lifetime plus 70. So at least it's going to be longer than that trademark that is not renewed. And even if you don't renew it, you could even lose it after 2-3 years. So it has the shortest potential lifespan, but also the largest potential lifespan. You need to note that for the test in case you're given that. If you're given one that's fairly easy, which one has the longest and shortest potential lifespan, it's trademark. But you need to understand the reason and rationale behind it so that you can answer a question. And those are the big 3. We don't have trade secrets. We don't have trade names as well, but the big 3 are usually what he asks about for those kind of questions. So for once again, going back through durations. Durations of a copyright is author's lifetime plus 70 years. For the publisher, it's 95 years from publication or 120 years from the date of creation, whichever comes first. And then for a patent, it's 20 years, but it's typically non-renewable, so it's going to have a definitive lifespan for the most part, generally speaking. Trademark, 10 years, can be renewed, so you can go an infinite time period. All right. And then at the very bottom, page 137 of your study guide, the trademark protection being lost if you abandon it for a period of 3 years, okay, or allow others to use that trademark, then it becomes too generic. Something like aspirin. Aspirin used to be a brand name. Now we call aspirin everything. All different types of aspirin, whether it's the brand name Bayer or whatever, we all call the different types of things aspirin. Escalator, elevator were examples of businesses that have been created. Now those are just generic terms, okay? Xerox is tried to keep their brand name, their trade name, their trademark name interesting and unique, although we know it is copying. They kept it, and so they've been able to register that trademark and keep it because they haven't let it become generic. They fought for it, okay? Whereas other businesses or other brand names haven't fought for it, it's become more generic. Once it becomes generic, once again, remember it cannot be too generic or you lose your trademark. We talked about that earlier. Now on page 138 of your study guide, what other things can be trademarked? Color schemes can be trademarked. We'll talk about Two Pesos Taco Cabana a little bit later on, but trademarks can be done. UPS uses that brown color scheme for their trucks and stuff like that, so note that. Sounds can be trademarked. Remember logos, short phrase, slogans, jingles, all that stuff. So sounds can be done. And if you look on page 138 of the study guide, in the middle of it, it gives some sounds. And it says the NBC 3-note chime, the MGM roar the lion for a movie. And then there used to be another one, the AT&T ringtone, that's now been taken out of the current study guide. And then also Harley-Davidson motor sound, but cannot be. Why do you think that the Harley-Davidson motor sound cannot be trademarked, whereas the NBC 3-note chime, the MGM lion roar, and from the previous study guide, the AT&T ringtone can be trademarked as sounds or distinguishing between similar or like-looking products to avoid consumer confusion? Well, the main reason the Harley-Davidson cannot is because, remember, when we talk about tort law, we're on an average person standard. Would the average person be able to distinguish between, say, a Kawasaki, a Yamaha, or a Harley-Davidson motor? And they probably can't. Now, a motorcycle aficionado probably can, but not the average person. And remember, we're going by the average standard. So if we made the Harley-Davidson was able to trademark their engine, then they would think all motorcycles sound like that, and they wouldn't be able to distinguish their brand name. So what we're trying to do is to avoid consumer confusion. If the consumer cannot tell the difference between a Harley-Davidson motor sound and a Kawasaki or Yamaha or something like that, we can't let Harley-Davidson trademark that engine sound. That's the reason why he could use any other thing, although Harley-Davidson has been on the exams before. I think it's one of the back of the study guide questions as well, or it used to be. But remember, he can make it anyway. You just need to know if it would avoid consumer confusion of the average person, because that's the standard we use in tort law. All right. I told you we had 3 other acts besides Lanham that you need to possibly know for the exam. And they're in that purple packet on that 2-page synopsis dealing with intellectual property. But the 3 acts besides Lanham, one is the Trademark Law Revision Act. This was in 1988, and it allows an owner to get treble or triple damages for false advertising compared to, and we're talking about trademark law. It's only available for businesses, not individuals. So if you're as an individual working as a business, you probably need to come up with some type of business entity, business entities being Chapter 9 on your next exam. Okay, the other thing that it does, besides getting you treble damages, is it allows you to register a trademark ahead of its use. So say I was wanting to start my own tutoring business and I wanted to come up with my own logo, my own short phrase, my own slogan, my own brand name and stuff like that. But I wanted to do it based upon maybe 4.0 and going out of business. So I don't want to leave quite yet. I can register all these things ahead of its use. Therefore, make sure I go through the T's and test system to make sure that it's not being used by someone else, but I can register it ahead of its use so that now, if I want to use it in, say, 2022, I have it already available, okay? And I don't have to try to quickly go through all the paperwork, quickly go through the whole process to get it done at the last minute, okay? The next one is the Federal Trademark Dilution Act of 1995. The 2 main things is blurring and tarnishing. Now, blurring and tarnishing are terms used where you're talking about how your product is perceived in the world relative to some other product. When we talk about blurring, We're talking about using a product unrelated to some other trademark, and you're kind of infringing upon their good name or reputation. So think in your head, what is a good business? A good business that people like. Say it's Apple, iPhones, okay? And I'm wanting to sell bicycles that Apple has nothing to do with it, but rather than having Mark's Bikes, which isn't making me any money, I decide, I'm going to go ahead and call myself iBike, okay, with a little I and then capital Bike or something like that, to kind of go with the iPad, the iPhone, whatever other I product there possibly is. By doing that, people think, oh, these bicycles must be associated in some way to iPhones. I love my iPhone. I love Apple products. Therefore, I'm going to buy this product that is totally unrelated, and I'm infringing upon Apple's good name or reputation to try to entice the consumer to buy my product thinking, oh, it's related to Apple or has a good connotation in their thing. The other one is called tarnishing. In the Federal Trademark Dilution Act, we have blurring, the unrelated product trying to infringe on their good name or reputation. But tarnishing is where we try to take the other parties, the other businesses' good name or reputation, and tarnish it by putting it towards a negative connotation, okay? By using a negative connotation. An example of this was a long time ago, and it's funny because it's now at the very bottom, page 138 of the study guide, and I've had this in my reviews for years, and now it's in the study guide, okay? Way back, Coca-Cola had a Season's Greetings Christmas theme where they had Santa drinking a Coca-Cola saying, "Enjoy Coke." Well, some college students, I believe it was college students, decided they'd make up their own posters that had Santa snorting lines of cocaine off a mirror saying, "Enjoy Coke." Now, Coca-Cola, i.e. the manufacturer of Coke, didn't like this, okay? It puts a bad image, a negative connotation associated to the Coke product that they're trying to sell. Now, yes, it was a parody, and yes, it was a big joke. However, it affected their business, it affected their sales and stuff like that. If you use a trademark to take a negative connotation to something, then that would likely be tarnishing. Another example of this is you have the Garbage Pail Kids. They were going after Cotton Patch Kids way back in the 80s and early 90s, okay? If a Toys R Us and then Adults R Us, okay, if it's a Toys R Us, Adults R Us makes their own website with the backwards R, then that's kind of infringing upon Toys R Us. Toys R Us, a child's gifts and toys business, probably, even though now they're, I think, going through bankruptcy, probably doesn't want their image with that backwards R associated to maybe a porn, Adults R Us, escort website, porn website, sales of sex toys and stuff like that. They didn't want it because that would be something that would cause a tarnishing image to their product. So they fought that. Okay. In terms of internet, there's an Anti-Cyber Squatting Consumer Protection Act of 1999. And what it does is allows if someone else trademarks a famous person's name in bad faith, then the owner of that trademark or the owner of that name can have it taken away from them and get it for them. Take an example of Johnny Manziel, Johnny Football, Johnny Manziel, way back in 2012, okay, when he became famous. If someone else registered Johnny Manziel or JohnnyFootball.com before he had a chance to, the Anti-Cyber Squatting Consumer Protection Act would allow Johnny Manziel to probably get those names back from the person that trademarked them, as long as he did it in a quick fashion. If he didn't do it in a quick fashion, we have a problem associated to it, okay? But this gives them the ability to do it, to get it. And it's considered to be a felony. If you cyber squat, you're registering someone else's trademark or a famous person's name in bad faith and hoping to either blackmail them, use it, or sell it to the rightful owner, or to maybe sell products that he doesn't say Johnny Manziel, Johnny Football doesn't endorse. Okay. Now, on page 139 of your study guide, it talks about trade dress. We talked about this with the distinctive look, the color schemes, and stuff like that. Under trade dress, which falls under the general guidelines of trademark law, trade dress is where someone steals the look of a competitor. If you think about Two Pesos and Taco Cabana, both of those businesses sell greasy Mexican food, usually to college students, drunk college students maybe, okay? And one of them has like a light blue, a pink, and a yellow. The other one has a light green, pink, and a yellow. neon. So you really can't tell the difference, especially if you're drunk. Think about it. If you're drunk, you can't tell the difference between those color schemes and stuff like that. So Taco Cabana and 2 Pesos looked very similar. They found that 2 Pesos had violated the infringement against Taco Cabana and found that this was an illegal action too close in color scheme. Now, Walmart had some knockoffs, so to speak, or less valuable products that people are like, oh, it looks like, say, a Coach purse, or it looked like a brand name jean, but it's only this price. Well, think about it. Say you have Miss Me jeans. Okay, Miss Me jeans go for, according to my wife, I guess, about $100, $125. Maybe you pay an extra few dollars if there's holes in them, which I don't understand why you're paying more money for holes already put into them, but that's beside the point. Say Walmart was to make their own jeans, and they were only to charge $19.99 for them. Now, if the Miss Me jeans are $125, maybe even more with the holes, and the Walmart knockoffs are only $19.99, then the average consumer of Miss Me jeans would recognize that those are a knockoff. You're not going to be able to get these Miss Me jeans, at least retail at the very beginning, for $19.99. So it is a knockoff, and they understand it. That's why Walmart was able to win their case. There was enough of a distinctive difference between them, and the average consumer of those Miss Me jeans would realize that these Walmart knockoffs, say they're the Doobie jeans with the holes in a different place, this is a knockoff, and therefore it's not going to be the exact same. And a price difference is usually going to be an indication of that. A Coach purse, if you change the C to an R, it's a Roach purse. The Roach purse may be only $20. The Coach purse is probably $300. This would be an example of something that would probably fall under trade dress, where the person that did the knockoff for the lower price would be able to probably win the case, because the average person that buys a Coach purse would know that you can't get one for probably $20, at least not the real thing. Okay? All right. We talked about under Lanham, what cannot be done can otherwise be done under state law. It still must be unique and fanciful under that. That is at the very bottom of page 139 of your study guide. All right. Trade secrets at the very top of 140. Just understand there's not much available to you. There's not really very much at all. State law is going to generally protect trade secrets. Federal law, the Uniform Trade Secrets Act, isn't very helpful. It does have some. But trade secrets is, it tries to help a business keep a secret away from its competitors, so the competitor can't get it, like a consumer list, a price list, research, formulas, whatever. So why wouldn't, say, Coca-Cola just go ahead and patent their formula to Coke, and therefore, even if someone steals it, then they have a 20-year right to exclude others. And that's the problem. You have only a 20-year right under patent law. Once that's done, then you can make a generic equivalent of it through the, maybe tweak a little bit of the formula, and then you have a generic equivalent you can sell for whatever you want to. So it's better for trade secret law to keep it private and not let anybody steal it. That espionage, the trade secret, that's what it's going to be. Now, as long as you try to keep it a secret, there are business level protections at the state level to try to figure out to help you. But for the most part, the federal law is not very helpful, the Uniform Trade Secret Act. Okay? So why would you go trade secret versus patent? Because trade secrets can last longer than the 20 years if you can keep the espionage, the secret, away from their competitors. Okay? All right. I believe that is it for the different types of intellectual property. We are now on page 141 of the study guide in terms of business negligence. Now, remember when we did the intellectual property, there's about 15 pages or so of the study guide. I narrowed it down to 2 pages in this packet, and there's a group of 30 questions on it. But I went over the things I've heard about. There may be things, little things that get thrown in there. Every once in a while, I'll ask people, and there's a couple of things like the tease and test system, or the arbitrary fanciful stuff that gets added because I hear there's a question on it. I'm not saying that we went over everything in great detail, but we did go over things I've heard about. All right, now we're on page 141 of the study guide dealing with business negligence. In business negligence, the first thing you need to realize is it is an unintentional tort. Everything we've talked about, all the personal intentional torts, assault, battery, false imprisonment, infliction of mental distress, invasion of privacy, defamation of character, malicious prosecution, fraud, all of those were personal intentional torts. Business intentional torts, such as product disparagement or just disparagement, false advertising, interference with contractual relations, interference with prospective economic advantage, not used in Texas, those are business intentional torts. Trespass, conversion, trespass to personal, real property, nuisance, intellectual property infringement. Those are property intentional torts. Once again, intentional. Now we're talking about negligence, which is an unintentional tort. Unintentional means you didn't intend for the action to occur. You didn't intend to do the harm. You didn't intend to do the action that resulted in harm, is a better way to say it. Now with business negligence, we have 4 basic elements, and all those elements have to be there. You have to have a breach, you have to have a duty of care, you have to have a breach of that duty of care, you have to have causation, and then you have to have harm, okay? Now, if you look on page 141 of your study guide, it has those 4 elements. A duty of care arises when a person should foresee that their conduct would create an unreasonable risk of harm to others. And it gives the example of target shooting in a rural versus urban area. Basically, I like to teach the duty of care as anybody you're going to come into contact with is in your bubble, okay? And you have a duty of care that your conduct is not going to come create an unreasonable risk of harm to others. And if you think about it, and you can even apply the coronaviruses that we're going through right now. If you know you have the coronavirus and you go out and associate all different people in College Station, you could spread the disease because you have a duty of care or you have conduct that could foreseeably cause an unreasonable risk of harm to others because they're within your bubble. Pedestrians, motorists, when you get behind a car in Bryan College Station, you would have a duty of care to those people because you could foreseeably come into contact with them, an unreasonable risk of harm based upon your conduct. But you don't have, say, a duty of care to Eskimos in Alaska. You're not going to foreseeably see them and you're not going to come in contact with them. So there's no duty of care to those people. So remember it in terms of a bubble, okay? If you shoot a gun in an urban area, you're going to have a much bigger, large number of people in that bubble versus a target shooting in a rural area, which is only going to maybe have a few people in your bubble. Same basic idea. If you allow someone, because of your conduct, to become unreasonable risk and you cause harm to them, then you have breached that duty of care. So anybody that you harm in that bubble, so say you get into a car accident because you change lanes without looking, or you run a red light and you cause an accident, you had a duty of care. They were in your bubble, okay? If you failed to exercise care, i.e. failure to exercise care or breach the duty of care by causing them to be injured, then that is going to be element number 2. Now, when we decide that, we're going to use a reasonable person standard. And when we're talking about the level of care when it comes to failing to exercise care could be at a higher level depending on what you are. If you're an engineer, higher level for engineering, doctors, lawyers, etc. That would be something like that. Just the average person for driving is probably going to be the standard you're going to use. Now, if you look on page 141 of the study guide, it says injury or harm. I like to make that my 4th one because I always remember damage is going to be one. So let's go over causation real quick before we get to injury or harm. Okay? Causation is 2 things, cause and fact and proximate cause. In order for causation to be there, and remember you need all 4 of these elements, duty of care, breach of the duty, causation, and harm. But in causation, you have to have 2 quote sub-elements. One is a cause and fact, the other is proximate cause. You must have both for causation, and you must have causation for negligence. It's kind of like checking off. You have to have all 4, and for causation, you have to have both of these. The first one is cause and fact. And the way I like to teach this is, it's kind of like a logic statement, if then. If A, then B occurred, okay? Did A cause B to happen? That is what cause and fact is. Did A, running the red light, cause B, the accident, to happen? The answer is usually yes if you have an accident. So that is cause and fact. Actual cause, but for test. Okay? Then you have proximate cause. Proximate cause is also a part of causation. You need more than just cause and fact, you need proximate cause. Is it likely or foreseeable that A would cause B to happen? Did A running the red light cause B to happen? That's cause and fact. Is it likely running a red light would cause B an accident to happen? The answer is yes. So now you have cause and fact and proximate cause. You have both of those. You have causation. If all other elements are there, you have negligence, an unintentional tort. Now, associated to proximate cause, or is it foreseeable? Is it likely? Is A likely to cause B? Is a case called Palsgraf versus Long Island Railroad. This is a tier 2 case. A tier 2 case. And what this case was on Long Island Railroad, they had a train on an adjacent train track where someone was being helped on by the conductor or by a railroad worker. Okay. In helping them on the train, something fell. Fireworks in the passenger or the customer's bag went off, causing the ground to shake. Causing the ground to shake so bad that on the adjacent train track away on the other side, it caused the ground to shake, caused the platform to shake, and a weight fell on a lady's head, I believe. Okay? And the lady sued Long Island Railroad. Did the weight falling off the train track cause the accident to happen? Yes. So the but for the cause and fact is there. The courts did not find it foreseeable or likely that that whole chain reaction would cause the accident to occur. They didn't see the actions of helping someone on an adjacent train, on a different train track, on a different platform, would cause, and something dropping, causing the ground to shake because it went off, causing someone to get injured on another adjacent train track platform to cause it to happen. Therefore, when Palsgraf sued Long Island Railroad defended itself and won the case because there was a lack of proximate cause, which means the element of causation wasn't there. Therefore, there was no negligence. Okay? Now, after causation, did A cause B? Is it likely A would cause B? Then injury or harm has to occur. It could be mental, but it usually requires physical harm. And now we're going to be talking about more actual harm, not just defensive contact that we talked about earlier. All right. In terms of defenses to negligence, if those four things occur, a duty of care, a breach of the duty of care, causation, did A cause B? Did A likely cause B? And then damage. Once those four things are there, then you have a case for negligence. But there are defenses for the, quote, tortfeasor. One is assumption of risk. If the other person knew of a risk and voluntarily proceeded in spite of it, they cannot then sue for negligence and win. Think about going to a baseball game. You're told on your back of your ticket stub, it says, you're not going to be, you need to be ready for foul balls. Because if a foul ball comes and hits you, then you cannot then sue the baseball team or whatever, in theory, okay? Because you knew of a risk and voluntarily proceeded in spite of it. On a warning label for, say, a hair dryer, it says do not use near water. If you use it near water, you probably can't sue the manufacturer if you get electrocuted because you assumed a risk. You knew of a risk because of the warning label and voluntarily proceeded in spite of it. We're going to talk about this when it comes to products liability a little bit later on as well. Now, the next two things in the study guide on page 142 are contributory versus comparative negligence. And think about it this way. The old method is contributory. Not many states use it. Texas uses comparative, but not many states use contributory negligence itself. Let's talk about running a red light. So person A runs a red light, causes an accident by running, hitting a car that was going person B. So B really didn't do much wrong, but say if they would have been paying attention better, they would have known that that car wasn't going to stop. They could have slowed down, and or maybe they were doing something, they were texting quick and answer like a yes, no on their phone, and they weren't paying complete attention. So say the courts find them 10% responsible, and they find the person that ran the red light 90% responsible. Under contributory negligence, the person that is 10% responsible recovers zero, nothing, because they were partially negligent in their own right. So if he gives you a storyline and says the person, the defendant or the person suing, the plaintiff sues and was partially negligent, in some states, contributory negligence says they will get zero. Now, that doesn't seem right. Someone runs a red light, you aren't paying complete attention, so there's a small percentage of your fault, your actions caused, maybe 5-10%, but you get nothing. So now we have what we call comparative negligence. And what we figure out is the amount due is going to be based upon the percentage of the other person's fault rate. And Texas uses comparative negligence much more than contributory. So if the courts find that they were 90% responsible for running the red light, and you were 10% responsible because you were texting, you got hit by that car, you can sue them for, say, $25,000 worth of damages. You're going to get 90% of that in terms of damages under the comparative negligence theory. So you'll get basically $22,500 here, okay, the 90% of the situation, okay? And if it's close to 50-50, well, usually insurance takes care of that when it's a car accident, stuff like that. But then there's going to be a percentage of negligence if it's close to 50-50. The courts will have to make a slight determination there. Now, the last one is superseding cause. Now, this might be a multiple choice answer. I haven't heard about being an actual answer on the exam, but if some intervening act causes the action, for example, instead of the fireworks going off and causing the ground to shake, say it was an earthquake that caused the ground to shake, or a tornado that caused the weight to fall off. Those are natural disasters. That would fall under a superseding cause, okay? Someone else did it. Something else caused it to occur. We were just a byproduct of it. Superseding cause would be a defense for the tortfeasor. So you have assumption of risk, warning labels would come into play, especially with products, contributory negligence, old method, you recover nothing, comparative negligence, the new method, Texas uses this, you get in proportion to the other person's fault. All right, the next thing we have is strict liability and products liability. Strict liability is liability without fault. We do not care about fault when it comes to strict liability. Now, there's the Rylands versus Fledger case. I haven't heard about that being on the exam, but I would note about the coal mine, just in case you're given that. If you keep a wild animal under strict liability, no matter what care you use, if someone gets injured because you have a wild animal, say you decide you want to keep a tiger, saber-tooth tiger, or a white tiger, whatever, okay? And you put it in a cage, and somehow some kid sees that tiger, attractive nuisance tiger, and comes on your land, and either A, gets injured by that tiger because the tiger gets out, or the kid gets through the bars or gets its hand through the bars and the tiger bites it, then you are going to be responsible because it doesn't matter whether you took all possible care. It doesn't matter whether if it's a product, the defect comes out 20 years later. That doesn't matter. You're responsible under strict liability. And wild animals are blasted with dynamite, you are going to be ultimately responsible. If the dynamite causes a building to collapse, but it collapsed the wrong direction from what you thought it was going to be, you're going to be held liable for damages because you blasted with dynamite. Okay? Now, when it comes to products liability under strict liability, there's what we call caveat emptor. Caveat emptor is the old system. Let the buyer beware. Caveat emptor, or let the buyer beware. In the early 1900s, this was the caveat that we had under product safety jurisdiction. The caveat, let the buyer beware. If you bought a product that injured you, it didn't matter. You were responsible because you were the consumer. The buyer is beware. Now, over time, products have been changed. The liability issue products has been changed to go from caveat emptor, let the buyer beware, to caveat venditor, let the seller beware. And over these series of these 5 cases we're about to go over, we changed it from caveat emptor to caveat venditor when it comes to products liability. Now, in your packet, or basically an extra sheet I gave you, there's going to be a chart with a couple of charts that we usually do in class, and here's one of them. It is a 3-column chart with the 5 main cases associated with products liability. And if you look, I believe it's question number 18, maybe 19 in the back of the study guide, we'll look at a little while, there's a lot of questions that are on the exam that are similar to question number 18 or 19, dealing with a case name and what it deals with. You have now in front of you a 3-column chart if you've got that extra sheet that I'm talking about, okay? On one sheet, it has, and I'll show you the white copy here real quick, okay? It's something like this. It has a case name, what the problem was, and what theory was used. This theory between these cases goes from caveat emptor to caveat venditor, let the buyer beware, to let the seller beware. And now the manufacturer is going to be much more responsible for products that they make. The first case was McPherson versus Buick, and it established products liability based upon the theory of negligence. And we just got through talking about negligence. So the idea of products liability being based upon negligence was used. So we're using all the theory of negligence. And what it said was McPherson had purchased a Buick. The wheel collapsed, broke, the wheel fell off, and he went off the road and was injured. He wanted to sue the manufacturer directly, but at the time, we had a notion what we call privity. And privity is more into contract law, but what it says is that you can only sue the original parties to a contract. So here's the problem. If, say, Buick makes a product, they sell it to a new car dealership, who sells it to a new car owner, who sells it to a used car dealership, who sells it to a used car owner, who then sells it maybe to another used car owner, and say that's McPherson. Now the defective wheel has fallen off. Okay, I'm doing this in modern day standards. This is back in 1909 or so. Okay, the modern day standards. Well, the problem associated to that is, in order to sue, McPherson would have to sue the person he bought it from. They would have to turn around and sue the used car dealership. Would have to sell the used car, the person that sold it to them, who then bought it from a used car dealership, who then bought it from Buick. And so you'd have to have 6 or 7 lawsuits. What this idea, McPherson versus Buick, says, we're going to use the elements of negligence that we just discussed, and we're going to relax privity. And now McPherson can go all the way from point 1, where the accident occurred, and sue directly the manufacturer, i.e. Buick themselves, for the product's liability issue. So it relaxes the notion of privity and allows theory of negligence to be used in products liability law. The next case is Baxter versus Ford. Now, Baxter versus Ford is probably the biggest of the 5 on the exam and on your comprehensive final. It dealt with express warranties. In this case was about a non-shatterproof glass called triplex, which was supposed to not break, fly, or shatter. Okay, and what happened is it did not break together. It did not shatter. It did not shatter. It did shatter, causing injury to Baxter's eye, and he sued. The court held the manufacturer responsible because the people rely on the claim that they made, and this triple shatterproof glass was under the idea of a warranty. And since it was a written warranty or a language-based warranty, that is express warranty. So Baxter versus Ford dealt with triple shatterproof glass. They didn't triple shatterproof, and therefore caused injury to Baxter, and he sued. And then he was able to win the case associated to that because of express warranty. They also didn't require privity, but that's not the huge portion of this question. It says it recognized express warranty under state law. Okay. Now, the next case is Huntington versus Bloomfield Motors, and this is implied warranty. This is where, say, there's a part within in a car, and I believe what happened is the car veered off, the steering wheel spun, and the car veered into a brick wall. The gear shift impaled on someone, causing injuries. Okay, but here's the thing: say that gear shift wasn't under warranty. The courts can do either one of 2 things when it's not under an express warranty. They can create their own warranty after the fact, kind of like quasi-contract or implied in law contract that we talk about in contract law. They can create a warranty after the fact, or they can create a warranty on something longer than its express warranty. So say we have a part, and we're going to call it a gear shift, that had a 3-year warranty on it. In year 5, this part causes an injury to occur. Well, if the courts feel that the part should have had a longer warranty than 3 years, they're going to extend that warranty an additional maybe 5, 10 years, and now it's under warranty law. That's an implied warranty. Or if that gear shift didn't have a warranty on it at all, but the courts feel that it should have, they're going to create after the fact a warranty. This is called implied warranty. It's a creative warranty, kind of like quasi-contract, implied in law, where they fill in a missing element. There's no warranty technically. We're going to fill it in because it should have been there. Okay? This is also called implied theory of merchantability. We use those terms interchangeably on the exam. But Huntington versus Bloomfield Motors gear shift, that's implied warranty. The next case associated to it is Sindel versus Abbott Laboratories. In Sindel versus Abbott Laboratories, this is the DES case. A pill was made, DES pill was made, and you're no way to prove who made it. It was sold under a generic name. A bunch of different companies made this pill. Well, it turns out that this pill caused birth defects in children, okay? And so people wanted to sue for this DES pill because they were not notified of all these changes or all these things associated to the product. Several manufacturers made this generic product. There was no way to prove which company did. So say there were 5 companies, company A, B, C, D, and E, that all made this product, okay? And you don't know which company made it. If you knew which company, you'd sue them directly and you'd go after them for all the money. But say you have $1 million worth of damages. You sue for $1 million. Okay. You don't know whether to sue company A, B, C, D, or E. So you sue all of them as a given industry that make that pill. And it could be any product. If he gives you a storyline, it doesn't have to be a DES pill. It could be any product. And if you sue the manufacturers of all the generic product, and you sue them and you win a reward based upon not their fault, remember, products liability has nothing to do with fault. We don't care about the fault. We care about the market share. So if company A has 25% of market share and it's $1 million verdict, they're going to have to pay $250,000, $250,000. Company B has 10%, they're going to have to pay $100,000. Company C has 20%, they'll pay $200,000. Company D has 15%, they're going to pay. Company E has the rest of it, so what, 30% or so, that'd be $300,000. So here's what happens. You have 5 different companies all paying money, but only one of them made the DES pill or whatever product he comes up with on the storyline. Only one of those companies made the product that caused the injury, correct? So say company A made it. They only have to pay 25% or $250,000 of the damages, but they're 100% responsible. They should have to pay all $1 million, but they only have to pay a fraction. So under market share liability, a business who completely caused all the injury may only have to pay a fraction of the cost. Now, another way to say that on the exam, multiple choice wise, and the way the old professor did on the exam is a business under market share liability may have to pay damages to a plaintiff it did not even harm. If company A did it all wrong, they were one completely at fault. Company B, company C, company D, company E collectively would have to pay $750,000 because of market share. Okay. Now this came about in California, and as of right now, it's still only in California, but you need to note that for the test as well. The last one is Greensman versus Yuma Power, and I don't believe that one's even in the study guide at all in the book. Okay. In Greensman versus Yuma Power, this was dealing with a shopsmith tool, and the shopsmith tool had a shard of wood that came off and injured the person. They sued. And what this did was it allowed strict liability laws to also be in products liability. So it's strict liability in tort law for products liability. So the evolution is now using these strict liability standards that we talked about, that we're about to talk about, and we talked about with the blasting of the dynamite, keeping a wild animal and stuff like that together. Okay? Strict liability is on page 149 of your study guide, and it talks about only unreasonably dangerous products caused by a defect. If the defect comes out later, or the defect causes a dangerous product, causes a product to become unreasonably dangerous, then under strict liability, the manufacturer is going to be completely responsible with 2 defenses. And the first defense is misuse of the product from the way it was intended. So if I take a lawnmower and it says do not use to trim hedges, or do not use, do not, and I alter it to add in rockets to make it go faster because I hate mowing a lawn, then that would be doing something, adding to it that caused, and if a piece of glass or something comes out, hits me, and I sue, I can't sue because I modified the product from the way it was intended. Okay? If I did not heed proper warning labels, like I used a hairdryer, although I don't have any here, if I used a hairdryer in the water, dropped in the water, and electrocuted myself, I couldn't then sue under strict liability, because even though it was an unreasonably dangerous product, or use it in your water made it an unreasonably dangerous product, I was notified under the warning labels. So failure to heed warning labels would not allow me to sue under strict liability. Modifying the invention to do it completely different would probably not, or misuse of the product from the way it was intended would not allow me to sue and win under strict liability. Now, absolute, one other thing that you need to know on page 149, asbestos is absolute liability. Okay, but it's a class all of its own. And if it gives you a storyline about like mesothelioma and asbestos, you need to know that's probably going to be, there's going to be an automatic win for the plaintiff there. Okay, we are done with chapter 5. This is going to end this portion of the video, but we're going to go over a few questions in the back of the study guide. They're pretty good. We've already gone over a couple of the assault and battery cases, but ones that are pretty good. Number 2 is a pretty good one just for theory. Number 7 is a pretty good one as well. Let's see. Number 16 is a pretty easy one, but it works. Number 17. Now, number 18, what we just went over with those 5 cases. Number 18 on page 161 of your study guide is basically taking column 1 and using column 3, correct? And all you have to do is correct them. McPherson versus Buick was a case of negligence series, so the answer is A. He could have a bunch of different questions. This is something that used to be at the end of exam 2 when it was chapters 1, 2, and 3 for exam 1 and chapters 4, 5 for exam 2. What happened was he wouldn't finish chapter 5. And at the very last minute, he would be trying to hurry up and finish. He would go way over time and people were leaving his class. So he would basically spend about 30 seconds total for all 5 cases, go over them really quickly, like 30 seconds real fast. And the people that had stayed for 10, 15 minutes after the class was over heard those things. And the next thing they know, 5 questions are on the exam about it because he was upset that the people left, I guess. I'm not exactly sure why, but he put 5 questions on there. 18 is a perfect example of that. If you can read that 3-column chart that I gave you and you can do that, you should be able to answer most of those questions that come about there. Now, Baxter versus Ford, of those 5, is usually the one that can also be on comprehensive finance. Okay, we're going to end this video, and when we come to the next video, we are going to do chapter 6 material dealing with administrative agencies.